The independent contracting industry is under attack. I recently saw a video from Mike Rowe of Dirty Jobs where he talked about the PRO Act, and that sent me down a rabbit hole. I'm going to go over what has led up to this, what is happening now, and how some of the leaders in my industry are taking steps to try to protect their independent contractors. A new law in California and new rules from the Department of Labor are really going to make it more difficult to be an independent contractor. Let's get into it. My name is Michael Fire, and I run this YouTube channel, Field Tech Academy, to try to help IT technicians understand how to navigate the independent contracting business in our industry. But the changes here apply to all industries. I run a small computer repair business, as well as being an independent contractor myself, and I've done this since the year 2000. I'm concerned about how these changes are going to affect my ability to continue to be an independent contractor. Before I go any further, let me just say this video is for educational and entertainment purposes. I'm not an attorney and I'm not an accountant, so none of this should be construed as advice. So what's brought us to this point? California passed a law called AB5, and that went into effect January 1st of 2020. The goal was to address California employers when they hired individuals and classified them as independent contractors, supposedly incorrectly. One of the changes that AB5 implemented was to put in an ABC test to determine whether a worker was an independent contractor or whether they were actually an employee and being misclassified. Under this ABC test, the default presumption was that a worker was an employee. It put the burden of proof on the employer to force them to prove that who they were hiring was an independent contractor. And so they had to meet all three of these ABC test requirements. The three requirements are: the worker has to be free from control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. Number two, the worker performs work that is outside the usual course of the hiring entity's business. And number three, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So what was the goal of AB5? The idea was to stop employer abuse of the independent contractor classification. AB5 turned some independent contractors into employees. It was thought that workers were being taken advantage of and were being classified as independent contractors when they should have been employees and therefore entitled to minimum wage, overtime pay, expense reimbursements, health insurance, rest breaks, and on and on. It was supposed to create a level playing field between gig workers and regular employees. What are some of the drawbacks of this? From an employer standpoint, having an employee instead of an independent contractor adds a lot of costs and more regulation. Some companies may not be able to handle those higher costs and may have to raise prices on the same products or simply get rid of the independent contractor and not replace them at all. From a contractor perspective, an independent contractor may not want to be an employee. It's the whole point of being an independent contractor is you're working for yourself. You have freedom. So what's been the results so far? According to the Mercatus Center at George Mason University, self-employment decreased after AB5 by 10.5% on average for the affected occupations. Overall employment, which was supposed to go up, decreased after AB5 by 4.4% on average for the affected industries. AB5 didn't really create the hoped-for transition to employment and an increase in employment. The thing that drives me nuts is if this law was so great, it should apply to all industries. If employees are being abused in one industry, then are they not being abused in another industry? Well, that's not how government works. When this law was passed, they put in a slew of exemptions. So who got exempted? Let's see. It was physicians, dentists, psychologists, veterinarians, lawyers, architects, engineers, accountants, securities brokers, dealers, investment advisors, real estate licensees, private investigators, certain marketing and human resource professionals, and licensed manicurists and barbers who can meet certain conditions. Basically, this whole list of people aren't being abused, and this law doesn't need to apply to them. However, gig drivers like for Uber and Lyft and DoorDash and the trucking industry, and from what I'm reading, even technology independent contractors were not excluded. So those industries have to follow the rules while these other industries don't. Big money from companies like Uber and Lyft came into California after that to at least try to get their gig drivers exempted. And so they did Prop 22, and it passed. So the people of California passed it, and then it got held up in court, and then it got upheld in court. And it's a battle back and forth. But effectively now the gig drivers are now covered as independent contractors. As of March 11th, 2024, the Department of Labor has now implemented a new rule which changes the game for independent contracting from a federal level, and it's probably been inspired by California's AB5 law. The new Department of Labor law is called the Employee or Independent Contractor Classification under the Fair Labor Standards Act. I will link to it in the description. What irritates me about all this is it's not like it's a law that was passed by Congress. This is just a government department saying, you know what? I think we should do this. Were there a bunch of constituents hitting up their members of Congress saying, hey, there's a lot of independent contractor and employee abuse here. This needs to be fixed? No, it's government, and it's probably because they're trying to gain control and push more people into being employees and not being self-employed and having more control over their lives. The Department of Labor rule has added a 6-pronged approach towards interpreting whether or not someone is an independent contractor. So what are these 6 metrics to be classified properly as an independent contractor? Number 1, you have to have the opportunity for profit or loss depending on managerial skill. Number 2, it's based on the investments by the worker and the potential employer. Number 3, degree of permanence of the work relationship. Number 4, nature and degree of control. Number 5, the extent to which the work performed is an integral part of the potential employer's business. And number 6, skill and initiative. All right, so what do all those mean? So factor 1, opportunity for profit or loss depending on managerial skill. Can the worker determine or meaningfully negotiate the charge or the pay for the work performed? Can the worker accept or decline jobs or choose the order and or time in which the jobs are performed? Can the worker engage in marketing, advertising, or other efforts to expand their own business or secure more work? Can the worker make decisions to hire others, purchase materials, equipment, and or to rent space? Obviously, if you're doing all of those things, it's pretty clear that you're an independent contractor. Factor number 2, investments by the worker and the potential employer. Now this, to me, is the cloudiest one that even I had trouble understanding, but I'm going to tell you what I found on it. Under this factor, do the worker's investments support an independent business and serve a business-like function, such as increasing the worker's ability to perform different types of or more work, reducing costs, or extending market reach? And how do the worker's investments compare to the employer's investment in the overall business? Factor number 3, the degree of permanence of the work relationship. You've got 2 ways to look at this. If you're trying to be an independent contractor, the work relationship needs to be for a defined period of time. It needs to be non-exclusive. You can work for other people. It needs to be project-based or sporadic, based on the worker being in business for themselves and marketing their services or labor to multiple entities. If the work was more indefinite in duration, it was continuous or exclusive of work for other companies, then it's more going to look like an employee-employer relationship. They also point out that seasonal or temporary work alone does not necessarily favor classification as an independent contractor. So you could be seasonal and still be considered an employee. Factor number 4 is nature and degree of control. Do you set your own schedule? Does anyone specifically supervise the performance of your work? Does a company use technological means to supervise the performance of your work? And does a company reserve the right to supervise or discipline you? Does a company place demands or restrictions on you that do not allow you to work for others or work when you choose? Does the company control economic aspects of the working relationship, such as control over prices or rates for services, and the marketing of those services or products provided by the worker? If the employer is doing some of these things because of regulations, then that won't automatically mean you're an employee. They may just have to be following the law. And then number 5, the extent to which the work performed is an integral part of the potential employer's business. This one I don't like either, because when does a company hire somebody to do something that isn't integral and important to their business? This factor considers whether the work performed is an integral part of the potential employer's business. This factor doesn't depend on whether any individual worker in particular is an integral part of the business, but rather whether the function they perform is an integral part of the business. So it really isn't based on the person, it's based on the need. This factor weighs in favor of the worker being classified as an employee when the work they perform is critical, necessary, or central to the potential employer's principal business. This factor weighs in favor of the worker being an independent contractor when the work they perform isn't critical, necessary, or central to the potential employer's principal business. And finally, factor number 6 is skill and initiative. This one, again, to me is a little muddled. This factor considers whether the worker uses specialized skills to perform the work and whether those skills contribute to business-like initiative. This factor indicates employee status when the worker does not use specialized skills in performing the work, or where the worker is dependent on training from the potential employer to perform the work. Where the worker brings specialized skills to the work relationship, just that fact in itself is not indicative of it being independent contractor status, because both employees and independent contractors may be skilled workers. It's the worker's use of those specialized skills in connection with business-like initiatives that indicates that the worker is an independent contractor. So they're saying you could have an employee that has a very specialized skill set. Obviously, an independent contractor is going to have a specialized set of skills that they're using in other places in their business and working for other people. So it's really about whether they're using those skills to contribute to business growth and business initiative. So this is our new reality. Like it or not, this is what we're going to have to deal with. The main company in my independent contracting industry world is a company called FieldNation. They're a platform that creates a marketplace for companies to place tickets and for technicians to bid on and accept those tickets. FieldNation just operates as a middleman, as a referee. So FieldNation doesn't control the pay rates. They don't control who does the work. That's all a decision of the companies that place the tickets and the technicians that do the tickets. Now, there are different types of clients that I receive work from. The platform style like FieldNation, there's other ones like WorkMarket and Cloud Work Pro. They're just a marketplace. Then there are a lot of other clients that I deal with where it's a direct relationship in regards to I work for the client. Now, the client has their own customer, and that's who I'm servicing in the end, but it's a direct relationship to where I always work for the same company, and they may send me to different types of sites. One day it could be an Old Navy, the next day it could be Walmart, etc. So the question is, are these new rules and new laws going to affect my direct clients or my platform clients? One of the biggest platforms is FieldNation, and so they're taking some steps to try to protect their independent contractors. And before I get into what they're trying to do to help, if you're getting value today from what I'm sharing, please smash that like button and subscribe to my YouTube channel. It helps me to grow and provide content like this. And check out my website at fieldtechacademy.com. I offer one-on-one coaching for people that are interested in becoming independent contractors in the IT industry. FieldNation has listed some guidelines to try to help their clients to stay in compliance with these new rules and laws. Number 1, don't post assignments that are 40 hours a week with set hours. That's one of those 6 categories we saw in the Department of Labor rules. Don't post long-term assignments that last consecutive weeks or months. Don't require providers to work exclusively with you without the ability to do other work. Don't provide training on how to do the job in its entirety. And I think they're using that as the whole specialized skill thing, because if you don't have the specialized skill to do the work, then you may be classified as an employee. And then number 5, don't provide all the tools and equipment necessary to complete the job. So if the buyers and the clients on FieldNation use these 5 guidelines, then they should be in compliance to maintain technicians as independent contractors. What are some of the things that FieldNation is doing to try to protect their actual technicians as independent contractors? One of the things they're suggesting is to get set up as a registered service company. And that is a term that FieldNation has where you can get set up. You can have a company profile. You can have sub-technicians. FieldNation encourages you to use formerly employed technicians. In other words, you should be hiring people that work for you as employees and not hiring techs as independent contractors to work for you, who is an independent contractor. They're encouraging their technicians to carry workers' comp insurance They're encouraging technicians to obtain an employer identification number from the IRS. That again is another sign that you are your own company. And another way of trying to protect yourself is to employ 3 or more people. The bottom line is educate yourself on the AB5 law, Prop 22, the new Department of Labor rules, and look into the PRO Act that's sitting in front of Congress right now. Make sure you know what is coming, what has happened. Get in touch with your representatives and find out where they stand on these issues. And let's try to join together as independent contractors to protect our industry. And as always, my goal is to help you to get out in the field making money. I'll see you in the next video.